We have got three prominent speakers today who will speak for about 15 minutes each. Andreas Schwab, who is a member of the European Parliament and a rapporteur for a new report on the EEA and Switzerland in the Parliament. Dr. Erik Fossum, professor at ARENA, Center for European Studies at the University of Oslo, and Dr. Jóhanna Jónsdóttir. She holds a PhD in European Studies from Cambridge University and is a senior official at EFTA. And following their presentations, we hold panel discussions where Birgir Ármannsson, the chairman of Alþingi's Foreign Affairs Committee, will join us. So altogether, this session lasts for 1.5 hours. We plan to finish about 10:30. So let's move to the first speaker. I would like to give the floor to Andreas Schwab, who is going to talk about this upcoming or forthcoming report in the European Parliament. Schwab, Mr. Schwab, please, the floor is yours.
Good morning, everybody. Thank you so much for giving me the chance this morning to speak here in the context of this conference in Iceland, in Reykjavik. It's my first time to be here, but when I came here, I discovered a lot of points how and why I could feel at home here. So thank you much for your hospitality, and thank you so much to give me the possibility to talk a little bit about the report that the European Parliament has already done 5 years ago for the first time. It was the same title, European Economic Area, State of Play and Future Challenges, and at the time it has been done by a Polish colleague. But I have to disclose to you that it was my idea at the time already, because in the European Parliament it's the team of coordinators who decide what line for the committee to take in own initiative reports. And I came to this idea because I'm personally coming from a border region which is very close to Switzerland, in the south of Germany, between France and Germany and Switzerland. So it's, I think here it's very difficult to, but you can have an impression. And the people in my region, because of historical issues, are very convinced still that the European Union, that the European cooperation, that Europe is the best way that this continent has ever had since a very difficult history. But still, there is an ongoing debate about as to whether we have created enough fairness between those who are still well off in Germany and those who are better off in Switzerland. Okay, we have to admit that Switzerland is not a member of the European Union, and we take note of that. But we also see that no referendum can ever change the fact that Switzerland is in the middle of Europe. And therefore, we have to strike the right balance. And from this point of view, I think the report is very timely, just a year after the vote in the referendum in Switzerland on mass immigration. And I think it will be obvious that we want to be polite and modest, but that we want to be clear that the European Union is not a pick and choose issue, but a legal framework where everybody and every member state, be it in or be it out, has to take the responsibility that it has taken over by a legal contract, by an agreement. But I think you are not so much interested about Switzerland, but you are more interested about Iceland and the EEA in general. And therefore, I should start by saying that, from my point of view, Iceland is an important Nordic partner of the European Union. You can figure that out with a lot of economic data that shows that the exports, the economic balance between the European Union, between specifically some member states and Iceland, is growing and growing. That also Iceland had a very strong record of success in the cooperation in the EEA framework. Our political ties, and I'm very grateful for the President of the Foreign Affairs Committee to be here as well, the political ties between the European Union and Iceland are very strong. We are sharing nearly all of common values. And I think it's also important to note that Icelandic people and Europeans, as tourists or students, share more and more of a common European frame, and therefore I think the cooperation within the EEA has been important and successful for both parties. Now, my second point that I would like definitely to add to this is that the economic benefits of the cooperation in the European Union or the cooperation in the European Economic Area can only be realized if common rules are timely implemented and applied. Also in Germany, in my constituency, or wherever you look in Europe, you will find debates as to whether one specific rule is good or bad. But we are not talking in Europe about one specific rule. What the aim of the cooperation in the European Union is about is to create a level playing field for all competitors to face a strong consumer group that will be in a certain way balanced moving forward together. And that can only be achieved if we don't have a look only at individuals and their interests, but that we have a broader look in a common market. And a common market is still far away, to be honest. We have achieved a lot, but the Internal Market Committee has given me 2 years ago the task to draft a report on the topic of single market governance. And what we concluded there was that we have to improve again and again the timely transposition and the unique implementation of EU rules also within the European Union. And that we can still get a further, it has been a study that has been done for this report, it can still be a further 3% of economic growth without any reforms, without anything else, just by fairly and correctly implementing EU rules. But as I tell you, that doesn't mean that every single rule is always a rule that makes everyone happy in the European Union. I was also, and I think that is very funny, after some some media coverage yesterday, I was also the rapporteur for the Consumer Rights Directive, a very broad proposal of the European Commission 6 years ago. And for sure, it was a very difficult decision that we had to do in the Internal Market Committee, in the Internal Market and Consumer Protection Committee, how to steer this legislation. And it's still the case that not all of the outcome makes everyone happy. Some rules may be more favorable to some consumers, some rules may be favorable to some businesses, and you even can not easily strike the line for all 28 member states. There are some member states, for example, like Germany, that still have a 2-year period for guarantees. There are some member states who have even more. So it's not easy to strike the right balance, but what we believe in is that in the end, whatever rule we will apply all over the European Union, the economic benefits for all will be higher instead of having 28 different guarantees rule all over the place. And I think this is even an argument for business, also in Germany, to say it's the scale effects of such a common basis and common rules are still much better than compared to the situation we had 50 years ago, where we had a scattered market with 28 different rules in 28 different member states. So single market governance therefore has become also a topic in the current debate of the European semester, where the Euro member states, those countries that have the Euro as a currency, want to improve their economic governance. And for sure there is a lot of work to be done to reform, to stick to reform plans, and I won't mention some countries that are even not on the map here, but it's obvious that one part of this economic governance to strengthen the economic growth in the European Union must also be a timely and correct implementation of single market rules, because that's the driving force of the European economy. So I have a little bit shown you that the debate on how to apply common rules is a debate that is not only done outside the European Union, but also inside, because the transposition deficit, and we have a scoreboard where you can very easily see how member states implement and how fast it moves ahead, This debate is not just a debate in EEA countries, but also within the European Union. And therefore, we are faced with a common problem, but we are also having a common goal because we believe, and I don't doubt about that, to be honest, we all together believe that common rules in the European market, which in the end nonetheless has a lot of common values that we want to defend, is still in the interest of all of us, of all businesses and of all consumers, if you take the average. For sure, it might be possible that you find a small group of consumers in one given country that for whatever reasons had a specific rule that protected them better. It may be possible that you find in a specific small country one entrepreneur that had a better deal by protecting his market outside the common rules. But economically speaking, in the long run, a common market which gives the preference to competition, to fair competition, and to fair consumer protection is in the long run the better choice, and therefore we still believe that we should go down this way. What I already mentioned was the Swiss Immigration Initiative, which has brought up again the topic on how to proceed within the EFTA, within the relation with Switzerland. And as a neighbor of Switzerland, I can only tell you that our businesses are doing extremely well because of a very close cooperation. And that in this situation, I think it would be stupid to destroy what has been achieved. And therefore, I think it is obvious that the European Union tries to find a right balance of being clear that common rules have to be applied all over the place in the same way, but that also we take some time to try to settle the issue with our neighbors from Switzerland. We still face in Switzerland a similar problem that we also face in a certain number of EEA countries, and this is the problem that within the EEA framework, the EEA states have agreed to implement the same rules as in the European market without deciding on them, but that was the choice of the EEA states at the time. And there is unfortunately still a little backlog of implementation. And as I pointed out to you, if we want to achieve the common values of this common market, it's of utmost importance that this implementation is done at the same moment in all member states, and therefore we hope that all countries take it serious, what they have promised when agreeing to the EEA agreement. I think I made already some comments on what is a text of EEA relevance. For sure, there is a discussion in some EEA countries, but I could also make the same comment on EU rules, that on these directives that we are doing, there is always down a little bit in brackets text with EEA relevance, and that means it should also be applied to EEA countries. But what is not written is that the text is applied to all EU countries in any way. And also in EU countries there is a debate in specific moments on specific rules as to whether these are the right rules for the right issue. But this is decided in the end in a democracy by the parliament, and that's the way it is. And we try hard to find the right balance, but in the end it's majorities who decide, and therefore there is no debate on EU relevance of EU texts. And so I think we should avoid to have a debate on EEA relevance of a text, because the aim, as I pointed out, is a common market with common rules, which is not always easy. My third point is that I would like to make clear that in a globalized economy or in a globalized world, it is even more important to defend common values together. And I think this is the driving force that has led to the EEA agreement with those countries who didn't want at the time become EU members. I think the EEA, the cooperation framework within the EEA, is something that the European Union today would not offer anymore. So those who have achieved this status can be, from my personal point of view, very satisfied. But it is not a one-stop shop. It's not an issue where it leads all in one direction. It's a privilege, but a privilege with obligations, and therefore also here the common values have to be defended together, and that means that the common rules have to be implemented in all areas. And this is in a certain way also the aim of the report that I'm about to draft, which will look very similar to the report that we have achieved and voted 5 years ago, which is a call for a very strong respect of common rules, remembering all parties, the European Union, but also the EEA countries and Switzerland, to stick to what they have promised. And that will be the starting point for the debate in the European Parliament, where we will also hold a hearing on the 6th of May, where we invite interested parties from all parts to discuss with us and to explain what they see is positive and what they see as problematic in these agreements. And therefore the report will not call for an end of this cooperation, but it will for sure call for a very strong recognition of all the details of this cooperation that has been done. For sure, in politics, you never know. I think there will be once a vote in an island very close, between here and Europe, something like this, and that vote in the UK will probably make a very important point on the debate that is done not only in relation to my report and the EEA agreement, but much further. Nobody knows how this will end, and therefore we have to be very open-minded and very clear. It will be other points that are political of nature that we cannot totally oversee. Switzerland has taken a public vote, a referendum, where they said that they want to stop mass immigration. The European Union has been very clear that this is an issue that Switzerland cannot do in this way within the common framework, and therefore has to choose what they want to do. We could imagine that at a certain moment in time in the next year there will be a new referendum trying to figure out a broader cooperation proposal for Switzerland with the European Union, putting aside the referendum from last year. But as for Iceland, it's the same for Switzerland. This is a decision that has to be done in the relevant countries, which are independent sovereign countries, what the European Union and the European Parliament will always respect carefully. But we will remind in this report, and I think with a very broad majority, that this is then nonetheless clear that with this goes a very strong need to respect the agreements that have been taken and have been accepted. And therefore I think also today's conference can shed some light into some specific points that I haven't been able to address so far. And I'm also looking forward myself to the speeches of my colleagues. In any case, thank you so much for your attention.
Thank you very much. Now to our second speaker, Professor Fossum. He is going to present findings from his forthcoming book, which will just be out in June, titled The European Union's Non-Members, Independence Under Hegemony, and the book deals with the EFTA states. Professor Fossum, please.
Thank you very much, and thank you very much for the invitation. It's a great pleasure to be here. Of course, Iceland and Norway have been historically deeply related, and of course are also the two states that are probably the most similar in terms of their relationship to the EU. Today I will give a talk that is to some extent an extension of a project we conducted earlier in connection with the Norwegian constitutional anniversary last year. It was the 200th anniversary. And our take was to look at the current situation and to see what is left of the Constitution. So the angle I take is on democratic constitutionalism. I'm not looking at the economic aspects of the EEA agreement, because I do think there's a significant consensus in Norway that the EEA agreement is good in economic terms. I don't think many people have a problem with this. But I'm dealing with the political, democratic and constitutional aspects of it. And the title is rather interesting. And the book is actually dealing with these issues. And I'll explain to you also why we are using these types of terms. Just as a backdrop, I think it's useful to keep in mind that there are 4 types of states in Europe, and that the states we are talking about today, the EEA states and Switzerland, belong to the states that qualify for membership but have decided not to be members. So that's a distinct category of states. There's, of course, also many states that do not qualify but want to be members. So I think just to keep that in mind as a kind of different groupings of states. And, of course, the two states do make up, they have formed different forms of affiliations. The verdict is that the EEA agreement is a hierarchical, multilateral, and therefore more binding form of affiliation. I think in substance, on the ground, what our Swiss colleagues are telling us is that the differences are formally speaking significant, but not so important in actual practice. But this is something that we can discuss. When it comes to Norway's relationship, and I think you already heard something about the EEA, you are rule taker basically only. And also I think what Norwegian legal scholars are saying is that indirectly Norway is subject to the EU precepts of supremacy and direct effect, even if the EEA agreement is a two-pillar structure with bridging institutions. De facto, there is a much more direct transfer of rules and regulations as if you were in a member state setting. And of course, being fully fledged members of the economic market means that Norwegian citizens are transnational market citizens and have the same rights to mobility and so forth as other EU citizens have. So that's another set of rights and obligations that ensue from the economic aspect of citizenship. The political dimension, of course, is different. And I will say something first about the nature of the relationship, then something about the EU and how that is changing the understanding of sovereignty. And then I'll finally say something more internally about the effects on Norway that we have seen from this type of relationship. And we also have to keep in mind, of course, that every state, whether it's a member or not, in these types of agreements, have representatives in the EU. So there are experts in the Commission groups, and also in the Schengen there's a more extensive form of presence. And the Norwegian Parliament also has forms of access to the EU. And remember, this is not only in the vertical sense, but it's also, in relation to the European Parliament, but also in terms of interparliamentary coordination. But this is on invitation. It's a special guest at these COSAC meetings that are meetings among parliamentarians. It's not, they have to actually formally send a request, and then they are invited. And they're also present to have listening posts in the parliament. Now, this is not, however, as I said, it's a rule taker, and this is not a system of joint decision making. The Norwegian Parliament passes laws, but in reality, those laws are have already gone through the legislative procedure in the European Union. So therefore, we can say that Norway's relationship to the EU is one of representation, but without politically elected representatives in the EU. So then I want to say something, what this actually is. If you look at this, the thinking about representation, what does this actually signify? And the term I came up to the closest is something that Edmund Burke framed in the late 1700s, namely virtual representation. So I have a definition from Burke that is that you are being represented by somebody, but you do not actually elect those representatives yourself. That's what Burke was using. And Burke's idea was that there should be an affinity in interest and also in ideas. And that's, of course, a question. Burke operates with the idea of rather long-term and unified interests. And in pluralistic and dynamic situations, it's very difficult to find that this can operate. So the whole idea of virtual representation is somewhat problematic, but the structure of the relationship is one where you are being represented by others. But you have no say in authorizing or holding these representatives to account. And this is actually a pre-democratic, it's a paternalistic form of representation. And it was actually also what the American colonialists were rejecting in those days. And he, of course, Burke was also then siding with the American colonialists and with the Catholics, saying that they were not adequately represented, even if the UK Parliament in the day said that they would be speaking on their behalf. Of course, Norwegians have been making efforts to obtain representation by soliciting other representatives to speak on their behalf. And that's called surrogate representation. You're looking for surrogates. And the Norwegians in the early stages of the EEA agreement had high hopes that the other Nordic states that were members, who joined when basically the EEA agreement came into effect, that they would speak Norway's case. I think they have generally been disappointed by this because of the conundrum. It's not only the dependence, but the fact that these representatives have few interests to promote Norwegian interests because the Norwegians themselves have chosen to be in this situation. So this situation is one in which you have a one-way kind of relationship. So why, then, is this presence or political representation in the EU so important? And I think what really should concern us here is that the EU alters the substantive contents of state sovereignty, not the formality. States are, of course, formally sovereign. However, the EU reprograms the manner in which states operate in a rather fundamental sense. And it is in a more horizontal way than you normally think. It's not an imposition by the EU as a separate level of government, but it's the fact that it brings together representatives of citizens and states in EU institutions that are making decisions in common. And that's what often is referred to as pooling and sharing of sovereignty. So this is basically the situation, and that's a difference what you normally think about in terms of sovereignty. The pooling and sharing, of course, is something that is consensually made. States have agreed to do this. They have gone through formal decisions, and they've also had referendums through the various treaty changes and so on. So this has happened in a reasonably democratic way. I say reasonably democratic, but it is how you operate in international affairs, and this has been subject to procedures in a sense. This implies that participation in common institutions is needed in order to influence those decisions that the EU's member states have agreed to undertake in common. And what I also think is fundamentally important in this, partly because of the lack of really watertight compartments between issue areas, means that the EU, as I say in the second line, appears to be moving towards a system where institutions of joint decision-making increasingly shape and set the terms of each state's domestic sovereign rule. I think this is fundamental, because this is the fundamental actual constitutional component, that if a state no longer sets the terms of its own domestic sovereign rule, how it is supposed to be conducting its own affairs, not the ones it does in common with other people, but its own affairs, then something fundamental has taken place. So the upshot of this is that you need EU representation in this kind of system in order to ensure both a say in common affairs, but also to have a say in the setting of the terms under which you are operating yourself. So the implication here is, of course, that this also involves issues that are not formally included in the agreements that states have signed with the EU. There's a spillover in that sense. Because, of course, insofar as the second development proceeds, it will entail the entire framework of decision-making in a political system. That's why this is a constitutional issue. And what we see then with non-members, of course, is they lack access to those decisions that EU member states have taken and have agreed to undertake in common. But they also lack access precisely to set the terms. So if this development of shaping the conditions under which states determine their own situation, if that is proceeding, then this particular deficiency will become also very problematic. So the more the two conditions apply, the more fundamental the challenge is to the constitutional democratic arrangements in the non-members, in these particularly closely affiliated non-members. Keep that in mind. So you could say that this would then could almost talk about as arbitrary domination. It's not arbitrary, but it is a system of domination, because you have no say in the setting and determining of the rules. So I think it's important then to say that domination is an unintended effect, because the EU is not set up to dominate states. It's precisely a co-decision system. But when you decide not to participate in those bodies that actually determine the conditions, not only of common rule, but also of how you conduct your own affairs without necessarily wanting to submit to other states, then this ends up being a system of domination. That's why we have the issue of domination in the title. But it's very bizarre, because the arbitrariness is very limited in this sense, because it is rule-bound, because the EU has set up provisions. We heard about this, about legal uniformity and the procedures in the EU. So this is a very unusual form by which you are somehow voluntarily subjecting yourself to something that is ending up looking like a system of domination. And then, of course, the quality of your own system depends a lot on the quality of that system that you are subject to. And in fact, one could argue the quality of your system is more dependent on the quality of that system that you are party to than it would be for those that are actually members and can affect and reshape that system. So that's why my argument is that this is de facto a constitutional issue and with deep democratic implications. Then I've also said something about the effects on the non-members. And of course, it follows from what I said earlier that EU integration affects the delineation of what are domestic and what are external issues. And the EU is really bizarre in that sense, because it's an upside-down kind of federal system. It is regulating in common those issues that were normally understood in states as the most internal issues, whereas many of the issues that are external are still more or less under the control of states. So Josef Weiler, one of the foremost legal scholars of the EU, talks about it as an upside-down kind of federation. So that means that the state's hardwiring, in a way in which it's dealing with domestic and international affairs, is, of course, reshaped by this. And what my argument is that this gets a particular twist in the states that are closely affiliated but are not members. In member states, this hardwiring is changing, but the whole systems are changing because they are part of the system. Whereas in the closely affiliated non-members, it gets a particular twist in terms of the way in which the state operates to deal with its domestic and with its external issues. So one of the implications is that people are talking about the EU as a case of executive dominance. That is, that elected and non-elected officials and experts play a very prominent role. And parliamentary assemblies in the EU are catching up, trying to keep them under control. Of course, my argument in the EEA situation is that this will become more prominent. And there's actually also a paradox in the sense that the more proactive the government wants to be in the decision-making processes, the more this system of prominence of executives in the decision-making process will be pronounced, because the executive needs to be very early on, and it cannot really listen to what the citizens think about issues before it's actually staking out its positions, because it has to do that in relation to its international partners. You can say that the principal-agent relationship is almost reversed, in the sense that there's an external principal that's looking at the government, and the government becomes some kind of an agent. Okay, I'm pushing this, but that's sort of one way of thinking. So, but the conundrum for the government is, if it wants to have a say in the decisions, it also has to operate early in the early initiative stage, because that's when the terms under which decisions are taken will be determined. So this is a paradox, and the structure is such that it privileges the executive in relation to parliament in this sense. The other element is what I was saying about this hardwiring. In Norway, as opposed to in the other member states, the parliament is dealing with EU issues still as if they were external issues, and therefore its own dealing with them, of course, structurally speaking, it has to, but its own dealing with them is therefore much more passive, much more responsive purely. Partly because when the decisions are coming to the parliament, they are basically passed anyway. so they have to take it. So there's very little leverage for this. You can look at this if you examine the scrutiny committees and compare the Danish and the Norwegian ones. They are very dramatically different. The Danish one is an active scrutiny system that instructs the ministers. The Norwegian one has briefings by the ministers to the committee members. It's very, very different. We looked very carefully at the debates in this and seen the significant difference. And also, what we see is that when so many issues are bound up by agreements, of course, elections change the hue, because the politicians know that many issues they can't really fight over. So you get other kinds of spectacles. This is something that should have been more significant, more deeply investigated. You could imagine that you get a stronger symbolic aspect, more personality focus, and other kinds of interesting effects in the elections rather than over large packages of the direction of society. And also, I call it gag parties in the sense that any coalition government, and Norway has coalition governments, will have a constellation with at least one party that insists on not changing the status quo, meaning that the big governments that might want to opt for membership basically cannot do so because they will have to choose between being in government or pushing the EU membership issue. So there's a gridlock in the way in which the coalition politics are stacked in a sense. And that means that the membership issue, which is the fundamental constitutional issue, is put aside. And I also would argue that this stimulates the adaptation process because it depoliticizes the actual adaptation. Because people do not see the principled cumulative effects of the adaptation because they are focusing much more on single issues, because those are the issues on the agenda the whole time. But the larger picture is set aside because the parties have a big problem of dealing with it. So they cannot function as formulators of alternative constitutional visions of any credibility, basically. This is a very strong statement, but I put it on the table. So one possible effect of this could be that it could be particularly stacked in favor of populist politics and responsiveness. And also where you will have a constellation where parties would continuously criticize the elite and talking about national betrayal of the elite and so on. So you get a kind of a oppositional logic inside the way in which the political dynamic is set up. And there's also, therefore, a strong wear and tear on parties that are in government in terms of popular support because they are tied in to many types of obligations and they have a problem communicating to people why these decisions are in this form and shape, because they cannot take credit for those decisions that are favorable to citizens that come from the EU because they haven't themselves been party to making them. So the credit blaming game is also somewhat different because you don't have the credit taking option that member states would have. So I would argue that the Norwegian situation and the decision to stay out of the EU, formally speaking, was in protection of the old standard traditional understanding of state sovereignty, which is thinking about sovereignty as akin to popular sovereignty, where the people decide themselves. In this situation, where the substance of sovereignty has changed, this has turned into a very awkward and bizarre form of kind of hegemony. So, as I say, EU appears in this sense, and the closer the association, the more acute the problem is. The other thing about this is that you could say that on the one hand that the fact that you are subject to a system of regulation therefore feels like a system of domination. The problem also is that you have agreements that the EEA agreement is dynamic. Schengen is also, but there are a number of areas in between that are not regulated. Besides, Schengen has been incorporated in EU treaties, whereas the agreement Norway has signed with the EU is not. So when the EU continues to integrate, there are areas that are uncertain. So there's also a level of uncertainty in this that needs to be covered, because people need the same level of security in this situation too, because you are so closely affiliated. So uncertainty also emanates from lack of regulation, EU regulation. So it's a kind of a double bind in this. And of course, I think it is very important that, as I said, the quality is increasingly dependent on the quality of EU governance. And therefore, we have to examine the crisis and how that is changing the EU as well. And finally, I want to end up with a speculative note very quickly, just to bring up this, because I think this is something that could have significant bearings. This is a broad canvas, because early on one was thinking that the debate in the EU was on the first line between points 1 and 3. That is, that you would have a uniform process of integration or disintegration. What you can see now with states, the development of the monetary union, crisis responses, and also abstentions or exemptions and so on, is that you can get both differentiated integration and differentiated disintegration in the EU. And therefore, I understand why the EU is underlining the need to have common uniform rules, because it's facing these types of internal pressures as well. And of course, the UK is an interesting one that is somewhere probably moving, could be discussed at least in relation to box 4 in this kind of category. But states locate themselves differently in this, showing that the EU is a complex accommodation system of different forms of affiliation, even among members. And of course, the interesting point for the non-members, affiliated non-members, is precisely what this entails when the EU itself is quite differentiated. What does that imply for the nature of these states' relationship? Okay, thank you very much.
Thank you very much. Now to our third speaker, Jóhanna Jónsdóttir. Her title is Speeding Up the Incorporation of EU Acts into the EEA Agreement. Jóhanna, the floor is yours.
Thank you. I want to start by thanking the organizers for inviting me here today. It's been very interesting for me to hear these presentations that we've had before on the bigger picture, on how the EEA EFTA states and Switzerland relate to the EU. Before, as Baldur said before, joining EFTA, I used to belong to the academic world where I was also thinking about the bigger picture. But now I'm a bureaucrat, and we like rules and procedures. So my presentation will be a bit more technical than the presentations that we've heard before me. But I also just want to begin by asking, can anybody tell me what's wrong with this news clipping? It's tricky maybe for those who don't work, yes? Yes, thank you very much. And we at the EFTA Secretariat actually often see these pictures in the media where we are portrayed as the EFTA Surveillance Authority, but the EFTA Secretariat and the EFTA Surveillance Authority are actually two very different organizations, even though we both belong to the two-pillar structure of the EEA agreement. We at the EFTA Secretariat are assisting the member states in order to incorporate EU acts into the EEA agreement. The EFTA Surveillance Authority, on the other hand, is a much more independent body, which actually looks at the implementation of EU acts once after they've been incorporated into the EEA agreement. And this is two very different things. So I wanted to actually focus on this even more, incorporation versus implementation. And there's been a lot of talk in the media on how slow Iceland is at implementing EU legislation and so on. But there are two separate steps to this process. First, acts need to be incorporated into the EEA agreement, and then once this has happened and once all constitutional requirements have been fulfilled, then EU legislation is implemented at the national level, and that's where the EFTA Surveillance Authority comes in. But in terms of incorporation, what happens at the EFTA Secretariat is that when we've identified, for example, a new proposal for an EU act, we notify our member states. They look at this act. We discuss it in our working groups where we have experts in different areas from all the EFTA states, Iceland, Norway, and Liechtenstein. They come to Brussels. We discuss new proposals for EU legislation and whether there might be any problems, for example, for the EFTA states in adopting these acts. We often try to influence the EU as well. If we have specific views on an EU legislation, we invite representatives from the Commission to come to our working group meetings, also often representatives from the state which is in the presidency of the EU, and also increasingly now members of the European Parliament or the committees of the European Parliament. Then once an EU act has been adopted, we send out what's called a standard sheet, where the EFTA states have to confirm that this act is EEA relevant. They have to notify us whether they need any adaptations when we come to incorporate the act into the EEA agreement. And yes, they have to submit this back to us. Once this is done, we draft a joint committee decision, and the joint committee decision that has to then be adopted by the EFTA states and the EU in the EEA Joint Committee, which is made up of the ambassadors in Brussels of our member states and representatives of the EU. Once these joint committee decisions have been adopted into the EEA agreement, it can also happen that certain acts have constitutional requirements, which means that the parliaments of the member states have to agree to the act before it can enter into force. And after that has happened, the EFTA Surveillance Authority can start looking at the implementation. And so now, as I said, there were two separate aspects. First, incorporation, and then the implementation. Since I am speaking on behalf of the EFTA Secretariat, I will focus only on the first question. So, is there a problem in incorporating acts into the EEA agreement, or is there a backlog, which some people have called it? Well, a few years ago, I've been at the EFTA Secretariat for almost 5 years now, and it was pretty much at the beginning of my time at EFTA that there was an increasing debate on whether there was a recognition, let's say, that there was an increasing number of acts which were pending incorporation into the EEA agreement. So the acts which the EU had adopted and had not been incorporated, the number of acts was growing. And at meetings with the EU, it became increasingly clear that the EU was growing a little bit more impatient with the EFTA states. And firstly, let me just say that there is a clause in the EEA agreement which says that acts should be incorporated into the EEA agreement as closely as possible to the time which they are adopted by the EU. And this is, of course, the reason for this clause is to avoid any discrepancies on the internal market. Since the EFTA states participate in the EU's internal market, the idea is that the legislation in the EFTA states as closely resembles that of the EU as possible. But saying that again, it's impossible that there is no delay between the incorporation of the Act into the EEA agreement and its adoption in the EU, and that's because the incorporation of these acts is not automatic. This is a decision that must be taken jointly by the EFTA states and the EU, so it's impossible that there is no delay between the adoption of the Act by the EU and its incorporation into the EEA agreement. But there was, so in 2012, but there was sort of a feeling that this number of acts that were waiting was growing. So in 2012, we initiated some changes to the procedures for the incorporation of the acts into the EEA agreement. These were fairly minor changes. They mainly related to the increased use of reminders to the EFTA states if they were delaying their responses to the standard sheets, and also a more formalized method of the EFTA Secretariat looking at any potential horizontal challenges in EU proposals for new acts that were coming up. These changes, we found that they resulted in some short-term increase, speeding up in the incorporation of acts into the EEA agreement, but then in the longer run they fell short of really speeding up the process. So we launched, in the summer of 2013, we launched what was called the EEA Efficiency Project. And the goal of this EA efficiency project was to come up with new procedures which would make the incorporation of EU legislation even more efficient, so to speak. And this project found that in October 2013 there were 500, and if I remember the number correctly, 571 acts which were on the so-called monitoring list. And this is also a question of how do we define the backlog? Is it all acts that have been adopted by the EU but have not been incorporated into the EA agreement? Or is it acts which have been adopted by the EU and we've surpassed all the deadlines that we had for incorporating them? So there was quite a debate on how we define this backlog, but in the end we have quite a simple definition. And we have what's called a monitoring list, and these are all EEA relevant acts that have been adopted by the EU, which have not been incorporated into the EA agreement, for which the compliance date on the EU side has passed. And in October 2013, we found that this number was 571. The EA efficiency project also found that the average time for incorporating acts into the EA agreement was 16.8 months, so almost a year and a half. Whereas if we had been following the normal deadlines, the process should have taken about 3 or 4 months. So we found that we were exceeding the time limit. But the EA Efficiency Project, the steering committee of the EA Efficiency Project, as it was called, came forward with a proposal early in 2014 for changing our procedures. And these procedures were adopted by the EA Standing Committee in May 2014, and they entered into force on the 20th of October 2014. And there are basically 3 main changes to the procedures. Firstly, we have an early assessment of EA horizontal challenges in Commission proposals for Council and Parliament acts. And this means, because the EFTA states are not members of the EU, we can have certain challenges that maybe members of the EU don't have regarding EA-relevant legislation. For example, there can be what's called a two-pillar issue. Here's where we have maybe some sort of issue with the two-pillar structure of the EA agreement, whereby we have the EFTA Court and the EFTA Surveillance Authority on one side, and the Commission and the Court of Justice of the EU on the other side. There might be some issue in the Act which doesn't really fall well under this two-pillar structure of the EA agreement. We might also have third country provisions in the Act which don't fall under the scope of the EEA. We might have criminal sanctions or fines which also are normally not considered EEA relevant. So the idea with the new procedures is that we will have an early assessment already when acts are on the proposal stage before they've been adopted by the EU. We assess all these potential challenges. The Secretariat provides its assessment to the Member States. And the Member States, what's new, actually we were already doing this before, but what's new with the new procedures is that the EFTA states must then also get back to us and tell us whether they agree with our assessment or whether they have identified any potential challenges themselves. And this is done, of course, in the hope that we can address these challenges early while acts are still at the proposal stage, and then hopefully even make some changes before the act is adopted, and that would make the incorporation of the act into the EA agreement hopefully easier once it's been adopted by the EU. The second main change is that we have an early start to the incorporation of Commission acts into the EA agreement. Actually, most acts that are adopted by the EU are not adopted by the Parliament and the Council, they're adopted by the Commission. It's the old comitology process, so now it's called implementing and delegated acts. These acts, once they've been adopted by the EU, are published in EU registers before they're published in the official journal of the EU, and the idea with the new procedures is that we will actually send out information about the act and start the incorporation process once the act has been published in the EU registers, rather than once they've been published in the EU official journal, and that will give our member states a little bit of extra time to deal with the acts. The third part of the new procedures is that we have a fast-track procedures for straightforward acts, and these are acts that, by their nature, don't cause any horizontal challenges, which I was talking about before. They don't have constitutional requirements, and they are, just by their nature, quite straightforward. The Standing Committee of the EFTA states has adopted a list of categories of acts which fall under this category, which can fall under the fast-track procedure. And the incorporation of these acts into the EEA agreement has become more automatic. But of course, because of sovereignty issues, the EEA EFTA states will always have a chance to oppose this fast-track procedure. If they feel that the act actually does pose some challenges, then they can put a stop to the fast-track procedure, and it will then follow the normal procedure for the incorporation of acts into the EEA agreement. We will assess the effectiveness of these new procedures in 2016. In the meantime, I can tell you that there have been, according to the newest figures that I have, which are from the 25th of February, this shows that there are 443 acts on the compliance list, and this is actually a 25% decrease from the number of acts awaiting incorporation at the same time last year. We also see that 49% of the acts which are being incorporated, have been incorporated during this time, have been incorporated through the fast-track procedure. So it does seem like, based on preliminary findings, that the incorporation of acts into the EEA agreement is becoming a bit more efficient. But of course, it's a bit too early to assess this, and we will have a proper assessment in next year. And then, in case anybody is really interested in learning more about these new procedures, we have a handbook which explains in detail how they work. And this is available on our website. I also have a few hard copies for those who are very interested. Thank you.